Judgment in the matter of Commissioners for Her Majesty's Revenue and Customs versus Joint Administrators of Lehman Brothers International in Administration.
Lord Briggs will explain the decision of the Court.
Lehman Brothers International Europe, or LBIE for short, was the European hub company of the Lehman International Banking Group, which crashed in September 2008. LBIE was itself placed in administration on the 15th of September. The collection of its assets by the administrators rather surprisingly produced a surplus of some £7 billion after all creditors had been paid in full, the last payments to creditors being made on the 30th of April 2014. Under the UK's statutory insolvency code, provision is made for a surplus realised in an administration first to be used by paying interest to those creditors in respect of the period between the beginning of the administration and the dates upon which creditors received payment of their debts, generally at a rate equivalent to that payable on judgment debts. The creditors of LBIE therefore became entitled to share in some £5 billion worth of interest, which is usually paid out by the administrators in a lump sum to each creditor. For over 2 centuries, the UK's income tax legislation has made provision for income tax to be deducted at source from interest payable by certain types of persons. The tax is then paid to the revenue, leaving the net of tax amount to be paid to the persons entitled. The rules have changed many times over the years, but the obligation to deduct tax at source now only applies to what has always been called yearly interest. So the question has arisen whether interest payable to creditors in an administration is, or is not, yearly interest. The revenue say that it is. The administrators, whose job it is to serve the interests of the creditors, argue that it is not. The judge asked to decide this question agreed with the administrators. The Court of Appeal agreed with the revenue. A group of cases in England and Scotland between 1854 and 1983 laid down some useful general guidelines for deciding whether interest is or is not yearly interest. First, interest payable on what bankers call a short loan, for example for a week or a month, is not yearly interest. Secondly, for interest to be yearly interest, there must be some element of permanence in the contractual arrangement under which it is payable, such as a mortgage loan. Thirdly, the arrangement which gives rise to a right to receive interest must be something in the nature of an investment. Fourthly, the loan must not be repayable on demand. Finally, there must be some tract of future time during which interest will continue to be payable. If these guidelines are applied to interest payable in an administration, as the judge said, it did not look like yearly interest, mainly because it did not become payable in a stream of payments over a period of time. Rather, it was all payable in one go, once the surplus was generated and all the creditors had been paid their debts in full. But another group of cases between 1937 and 1981 have examined the same question in relation to interest payable in one lump sum, usually upon the order of the court, where it is designed to compensate the recipient for being deprived of money or of property during a period in the past. They include cases where a trustee has misused trust property, and cases where the court has ordered interest to be paid upon damages, for example, for the period from when someone suffered an injury until the date when the person who caused it was ordered to pay damages. In those cases, the question whether the interest ordered to be paid was yearly interest has been decided by reference to the length of the period of deprivation of money or of property in respect of which the interest is to stand as compensation. If that period is for more than a year, and it was usually for several years in the decided cases, then the interest so ordered was held to be yearly interest. This court regards interest payable in an administration as a special type, for which a solution to the question whether it is yearly interest needs to be found by analogy. Interest in an administration is payable in respect of the period from the beginning of the administration until the creditors receive payment of their debts. During that period, the creditors are, like the beneficiaries of a trust or the person injured in an accident, being kept out of their money or property, because they cannot sue the company while it is in administration. The interest is paid as compensation for the creditors being out of their money during that period. This court, like the Court of Appeal, finds unanimously that the second group of cases to which I have referred offers a better analogy with payment of interest in an administration than does the first group. The interest payable in this case, as compensation for a period of deprivation of up to 5.5 years, is therefore yearly interest. And this appeal is accordingly dismissed.
The court will now adjourn.